Welcome to Heald Law Academy, the place where you can quickly learn how to maximise the value of your businesses and safeguard your commercial and personal interests. I'm joined by David Dees, and we're going to take a look at intellectual property rights and how easy it is to lose control of your precious designs when you employ consultants or contractors. David, firstly, when we talk about intellectual property, what are typically the most important things that need protection?
I think in this context, what we're really thinking about is copyright. Copyright relates to the creation of something original, and I think for most businesses these days, it's either some sort of design or software.
Now, we hear a lot about intellectual property in staff contracts, but why is it more difficult with contractors?
One of the fundamental points about copyright law in England and Wales is that the creator of the copyright work owns it. That's the default position.
Even if they work for a company?
Absolutely right. That's where people go wrong. It is slightly different if you're actually employed as an employee, because there are provisions which state that the employer owns the work that's created by the employees while they're at work. But of course a lot of people, particularly in the IT industry, are using contractors who are not employed by them at all.
Now, the idea of intellectual property seems quite almost tangible. It's very abstract. If you've not actually got a product to protect, can you protect an idea?
Well, unfortunately, you can't protect an idea. Let me give you an example. What if you thought it was a fantastic idea to give instructions to computer users by using pictures rather than code? Great idea. We now call them icons. They're quite commonplace. But that idea of itself can't be protected. What you protect with intellectual property law is the implementation of the idea. It's the expression.
How do you prove that it was your idea? How does someone in a company be like, that is my idea?
Well, it can be very difficult because sometimes people invent things at the same time. The history of cameras, for example, is littered with examples where people claim to have invented something more or less at the same time as somebody else did. But anyway, in the modern world, if it's a piece of literary work, people can put the C symbol on, copyright, which is a common and perfectly acceptable way of indicating that you own it. Things can be dated. And of course, if you're working in the IT industry, everything has got a date on. We know when software was written, when it was delivered, and yeah, that's not really a problem.
So you could create an idea, put a copyright on it in the sense of you've made something to copyright. There has to be an actual product.
Well, you keep using the expression products. It's often not a product. The problem with intellectual property law for lay people is that it's a bit of a smorgasbord. There are lots of different ways of protecting intellectual property. There's no one unified system in this country, unfortunately. There's copyright, there's design right, there's patent law. They're all slightly different, and you've got to get your idea or the expression of your idea into one of those particular compartments in order to protect it.
It sounds almost like a very grey area that the average person wouldn't know specifically what's the best approach to go about copywriting something. Can they get advice from you?
Of course they can get advice. The beauty about copyright is you don't need to do anything. You get copyright by virtue of having created it.
Just naturally.
Absolutely right. You don't have to register it. In fact, there's no registration process.
But how do you prove that that was your idea?
Simply evidence. There is plenty of case law on this subject, and people have gone to court over who created it. And I'm afraid that's just a fact of life. You have to document what you've done. And in the context of most businesses, as I said earlier, it's pretty straightforward, because you know when something is created, you know when you ask the contractor to do something for you and when they gave you an output, and you can easily say, well, that was created on that day by that person. The key thing for copyright is it's the expression of the idea that's original, not the idea itself.
So in terms of advice, would your main advice be to document everything, particularly if you're a business that is hiring contractors?
Certainly document everything. The most important part in this particular context is to make sure that the contractor or consultant assigns the right of ownership to you. Most people think that if you pay for something, you own it, but unfortunately in that world you don't, because it's the person that creates it that owns it. So if you're making a contract with a contractor, make sure that they assign the created work to you so that you own it when they walk out the door.
People must be really surprised to find this out, if you've paid someone to do something and then to find that you don't actually have any rights to that expression of an idea.
Yeah,
like
yes, they are. And the classic one which comes up and again is to do with websites. People think, great, we'll have a website. I've got all these ideas. I've got these designs. This is how I want it to go. So they get someone in to come and do it. And we know there are lots and lots of very good web designers. They build you a website. You think you own it because you paid their bill. But actually, a lot of what's on that website is owned by the web designer unless you do something about it.
So before making something, for example, a website, you could put in place an agreement that says, I own the copyright to this once you've made it.
Correct. You should do that. You should make sure that the website designers assign the rights to you. Now, of course, there can be then a commercial negotiation here, because often disputes arise where the owner of the business wants to repurpose what has been created. It may have started out as a simple brochure website, but they may think, great, we'll do some videos, we'll go on the telly. And the website designer is going to say, hang on a minute, this material was made for that purpose and now you want to repurpose it. I want some more money.
So in that case, you have to continually, readjust the agreement.
You may need to continually readjust the agreement, but it would be much better right at the beginning, while you're holding all the cards, to say that any IP created by you is owned by us and we can use it how we want to later on.
And on the flip side of that, say someone didn't take these precautions because they didn't know, as I'm sure lots of people don't know. How easy is it to do the reverse? So say I pay someone to make me a website and then I want to do something with that website and they say that I can't. How easy is it for me to do something with the website without the right?
It's very, very difficult. We've had examples in the office where people have come and said they've switched off the website. What can they do? I know, and they can't trade.
That's
it's a potential disaster for them. Yeah, you have a dispute. You have a dispute. And if it hasn't been documented properly at all, then there are various cases which decide who owns what. But that's very, very messy.
My goodness, so it can lead to a lot of complications.
Yeah, it can lead to a serious dispute.
So ultimately, get those agreements in from the offset.
Get it sorted out at the beginning when you're in the driving seat.
Wonderful. Well, thank you so much for taking the time to explain that to us, David. We hope you enjoyed today's discussion. If any of the issues mentioned are affecting your business right now, then simply call David on the number below and remember to subscribe to all of our videos, and we'll also send you news of seminars and other events where Heald Law Academy will be presenting. Bye for now.